Okay.
Karakia. That'll be good. Okay, we will just open with a karakia that we'll find. Hokirunga kia rangi e tu nei. Hokiraro kia papa e takoto nei. Hokiroto ki te nako tangata. Hoki waho ki tēnei hui. Humie, huie, tai.
Okay, tēnā koutou katoa. Nā mai haringa ki tēnei hui. Ko Robert Scott Pukaingo. Good morning and morena to you all. This is day 3 of hearing 1. I think the first submitter, we've done a little bit of a rejig, and I think our first submitter today is Mr. Peter Malcolm. Are you here, Peter? Yep. Malcolm? Yep. Come up here, sir, and have a seat. Welcome. Okay, have you got anything you want to give us in writing, or are you just going to be speaking to? Okay, that's fine. You might see me tapping away on my laptop. I can assure you I'm not watching cat videos on YouTube. I'm just writing down some notes on what you're saying. Okay. Be ready whenever you are, sir.
Okay, look, my name is Peter Malcolm. I support submissions S561 suggesting that 6-storey housing should be permitted in Kaikohe Town Centre, King Street. That's, and also around Kaikohe. 3-storey housing permitted in other residential areas close to the edges of towns such as Kaikohe and Kaikohe. The reasons, basically, there's a dire shortage of affordable housing, especially community housing, public housing in the area administered by the Far North District Council. Now, I'll just give you some examples. I know a person called Carol. She's 69 years old. She owns a 12-foot caravan. She both rents parks it on a property which is about 12 k's from Kaikohe. She pays $130 a week for that. The car that she has is 25 years old. The $130 covers basically power and water. So the car's unreliable. The caravan is very cold in winter, hot in summer. She's by herself. She has no family in the immediate area. So that's one person who could be beneficially affected by having affordable housing, especially community housing in the centre of town where basically you could walk to all services. Another example is the person I know is a guy called Bob. He's 61 years old. Once again, he owns and lives in a caravan. He pays rent. He's had a stroke, and basically he's paralysed down his right arm and part of his shoulder and so on. So he's limited in what he can afford to do. He has an old reliable car. Once again, he pays around about $120 a week, and he's about 10 or 12 comes from any services whatsoever. Other examples say Eva and Carol, a couple in their 30s, both on the minimum wage. They, over the last 5 years, they've actually had to shift their rental accommodation. They actually had to shift 6 times. They would ideally love to have a situation where basically they stable accommodation at affordable rates. The actual rent which they pay takes up one of their wages. There's that rent just pays for the so they want that wage, but basically just pays for the rent, the power, and just the essential services. They've got an old car. They would love to have some sort of stable accommodation which is affordable. And that's once again the reason why I think it would be wonderful for this public housing multi-storey in the centre of places such as Kirikiri and places such as Kaikohe as well. Now, one of the ways to provide such accommodation is to allow higher population densities in the town centres. Some of the benefits of higher population density include a more vibrant community. So you've got a greater range of people in a smaller area. There's diversity in the range of services available because basically it's more economically viable if you've got a greater number of population there. You have improved economic viability of essential public services such as reticulated water, sewage and transport. So you have those sorts of advantages as well. Now, personally, I believe that places such as Central Kirikiri is an ideal location for high density community, affordable public housing. It has reticulated water. My understanding is, although some people might disagree, it has spare sewage capacity at present, and it has low exposure to natural hazards. So natural hazards such as floods, because it's on a ridge 60 metres above, or about 80 metres above sea level, it's not likely to be affected by floods. It's not likely to be affected by things such as earthquakes because it's in the far north of the country. It's north of the south. It's probably the safest part of the country from a perspective because it's all on the Australian plate. So you're unlikely to have the major earthquakes which you're likely to experience in other parts of the country, such as the Bay of Plenty or, say, the Lower North Island on the east coast. And you've always got the Great Alpine Fault, which is looming as well, which is likely to hit in the next, well, will hit in the next 40 or 50 years. As far as tsunamis are concerned, it's well away from the coast, and once again, it's got elevation. So from the point of view of natural hazards, I think it's an ideal location. The other thing too, which I feel is that Central Kirikiri is easy walking distance of all essential services and facilities. So it's got supermarkets at hand. Basically, it's got schools, some of the best schools in the Bay of Islands. It's got North Tech there, presence as well. It's got intertown city transport hub there. It's got medical facilities. It's got churches. It's got a library. So there's very little need to possess a motor vehicle for people who are living in that particular location with those particular advantages. It also has government services such as MSD, and people are concerned about crime. We've got police that have by far the largest and most modern prisons in the north. And we've also got recreational activities are also catered for. So you've got the Kirikiri domain in the centre there. Basically, you've got other facilities such as the golf club, which is within close walking distance. You've got the sports facilities on the corner of the bypass and Waipapa Road. Once again, a couple of kilometres away, easy walking distance. And the other thing is that I would respectfully suggest that future growth of our towns needs to be upwards rather than spreading out, sprawling onto productive, irrigated land with versatile soils which surround towns such as Kirikiri and so on. I do want to stress that I have no vested interests in terms of owning land or property in the central young towns or as such, places such as Kirikiri or Kaikohe. So I don't have any benefit from it. I'm concerned about the actual social implications and looking forward to it in the future. So I seek the following, that basically 6 million housing development should be of towns such as Kirikiri and Kaikohe for numerous reasons. Thank you.
Thank you very much for your submission. So you're supporting the Kaikohe subdivision submission, and that's seeking the 6-storey high buildings in town centres and 3 stories elsewhere.
Correct.
So is your reason for supporting it the fact that it would provide for public housing?
public housing ideally, but also affordable public housing, but also the, for a number of people who cannot afford, for various reasons, cannot afford to actually go through pay big rents and who are disadvantaged. And if you look around, essentially, there are a lot of people around here and other parts of the country who are on the minimum wage, and even people who say on the living wage, which is only a couple of dollars an hour greater than the minimum wage. And they are finding it very, very difficult as well. And even say, I would suggest that some of the staff were employed by the Far North District Council and the contractors or the staff employed by the contractors are basically paid probably at the very least, or not much more than the living wage in many cases. Not so much the Far North District Council, but certainly some of the contractors, the actual minimum wage as well.
Yes, thank you. And thanks for your examples about people who are actually facing hardship. It's always beneficial to sort of humanise the issue. So thanks for raising that. And we've had a number of submissions, even though this is only day 3 of an 18-month process. We've already had a number of submissions talking about these particular issues and in particular to where they live and the experiences they see. So thanks, that's very helpful. Do you see this additional height applying in particular urban areas, or are you wanting to see it across the district?
Look, I'd like to see it across the district, but particularly in areas where there are relatively few natural hazards. If you look at places such as Kaikohe, for instance, there are a few natural hazards here, and you're well away from the coast. You're not going to be unlikely to actually face that'd be a massive one if you do. But also the other thing too, you're surrounded by some very good versatile soils. So if you have towns spreading out onto those, I think that is a waste of resources in the future. You look at places such as Kaikohe, for instance. Now, when I was a child, I knew the area quite well. It was a flourishing agricultural area. Now, the only thing that's growing, it was growing lots of crops. It was the vegetable growing area for Auckland and perhaps the Northern Cape. Today, with housing develops and so on, the only thing that's growing is houses and roads. Now, if a situation where you had the buildings actually being elevated, the change in approach that we're essentially where cities actually developed up, you wouldn't be compromising those versatile soils and flexibility in the future. But the other advantage too is if you've got compact cities, it makes the economic viability of the services which they provide, such as roading, transport, and so on, much more viable. So that's the reason why I said places such as you have to be a bit careful in places such as Kaikohe, in my opinion, because it has more issues as far as natural disasters, floods, and things like that. You've got a big river there. It's closer to the coast. It's lower lying. But places such as Kaikohe and Kaikohe, I believe, basically, the development should be encouraged to go up, not out. Or if it is going to go out, it should be on soils which are non-versatile, which do not have the potential for producing food in the future. And that's particularly the case around Kaikohe. Basically, you look up and down Kaikohe Road. You've got versatile soils there, but also that area there is on the Kaikohe irrigation scheme, which was put in place 40 odd years ago to provide water, irrigation water, to farming enterprises, food producing enterprises. Okay, that water can also be diverted to produce or supply water to the township of Kaikohe, and I understand at certain times of the year that but I think that's I think we've got to look after future productivity or agricultural productivity as well.
Thank you. And thank you also for clarifying you had no vested interests in any of these properties.
I don't. So I do not have any I do not own any property in Central Territory, Kaikohe, or any other part of the country.
Just out of interest, what is your background?
My background, I come from an agricultural science background.
Right, and look, I've just got one final question for you. This obviously is a hearing for part one of the district plan and the strategic direction. Do you have any particular provisions in that part of the plan that you'd like us to focus on, or any amendments to those, or is this basically a general submission for us to be aware of as we go forward? Okay, no, thank you. I'll just see if any of the other commissioners have any questions for you.
No questions, but I thank you. I'd like to acknowledge your kōrero that you've said here and giving us those examples of people that you're aware of in the situation. And from a planning, it is about up rather than out. And I think components around design when you build is, urban design. It's a enabling sense of place for those community members that do live in those in the 6-story or 3-story places. So I didn't have any questions per se, but thank you. I think we've heard lots for Kiri. Good to hear Kaikohe as well. And the need, being aware of that need. Kaitaia, as you say, has other matters to consider. So thank you for bringing that to light for us, which we've heard a lot for Kiri. So no, thank you for kōrero here this morning.
Thank you.
Just wondered if you had any comments about kia ora, Henia, Ngāweri for kōrero. Any comments about, you talk a lot about affordability, accessibility. How do you feel about rates increases in the affordability area?
That is a big issue. Look, I can fully understand the need to provide services, but I know that a lot of people are struggling with increased rates and the possibility that you're going to have double-digit rate increases this coming rating period. That is a concern, especially for people who are on a limited income. And I know there's some relief in some situations, but for people who are actually renting, that's probably not going to be a major impact, but it certainly does affect the people who are renting the properties out, and that puts pressure on them to start increasing the rents, which they have to justify or to meet their obligations as well. But no, certainly the rates issue is a big thing, and I don't know really how you overcome that if you want to provide the services. Look around the north, for instance, and you find that 2/3 of the roads in Whānau District Council are unsealed. So that's an issue for this particular council. And one of the issues you face is that you've got a relatively large area, you've got a long, narrow district, a low population density. So that means that the rates to maintain the services, the road in particular, is expensive. It also leads to it if you've got a number of smaller communities, providing essential services such as water is also very expensive, especially if you've got townships which are developing quickly. So that becomes an issue as well. It's very, very difficult. And I can contrast it with, say, a place such as Auckland, for instance. You might have a kilometre road, and which in a built-up area, you might have, say, 60 households or more on that particular section of road, taking both sides. Up here, you've got a farm, or you might have 2 farms on one side of the road, on that, covering that same kilometre of distance. But you're still got to go through and provide some sort of services. So that's a very difficult issue, and trying to find the right balance between actually providing essential services, but at the same time not making it excessively expensive for a lot of people who are finding it very tough just right now. If you look at the dairy farm prices, most dairy farmers I know around here are basically not going to make a profit this year. Sheep and beef are basically they'll be barely covering the cost side as well. So you're seeing, and this is reflected in things such as tractor sales, record low tractor sales, for the lowest tractor sales in the country for the last 30 odd years or so. So all those sorts of things make it very, very difficult, especially if you've got rates increases and so on coming on as well. And it's not as if a lot of those people can actually go through and say, okay, guys, obviously we want an extra $1 a kilogram for the actual stock or meat we produce to actually cover our increased costs. They don't, it doesn't work that way. They're price takers.
Commissioner Olkia Hadawira made reference to accessibility. So being mindful of more the elder age, having a sixth story can be a challenge for getting around.
What you find is in that sort of situation, if you look at someone like Carol, for instance, now she's quite mobile, but she doesn't, and if you're within walking distance, a couple of 100 metres of shops, if you look at, say, a place such as King Street in Kaikohe, well, it's 100 metres to the end of the street to Kaikohe Road. You go through, and just across the road, you've got the supermarkets. You walk another 200 metres up the road, you've got the district council offices here. If you walk, say, just across the road, you've got the library. If you're looking at things such as schools, for instance, you walk from King Street through Kaikohe Road, 100 metres, you walk through the domain, another 120, 150 metres, and you're at the high school. So if you've got the services here, so when you say accessibility, that's for the advantages of actually having, say, high density development in areas such as that because of the accessibility. Those services are all available in walking distance. You don't have to have a vehicle. As far as, say, if you're living on the top floor of a 6-story building, these days you do have things such as lifts and so on, and even mobility scooters and so on. You can also go through and scoot down the town if it's flat, which is the advantage of Kaikohe. So you also have the advantage of places such as Kaikohe. It's also relatively flat. And as I said, the services are there within easy accessibility. People such as Bob, good as a, he still can walk around, but he can, if it was within walking distance, he wouldn't have to worry about having to go through, spend time tinkering out of his vehicle to make sure it's reliable. And then when the vehicle breaks down, he's in a situation where he's got to go through and call upon other people to try and help him, and he feels embarrassed. So he has a certain amount of independence as well.
Thank you.
Thank you for your presentation, Peter. Just in regard to housing typologies, and you did speak about that question about multi-story housing. In your local knowledge, from your experience currently, the variety of different housing types, you talked about one of your friends living in a caravan.
Or two often in caravan.
Yeah. So in terms of the size of households in the townships, you talked about the size of the households that you've seen in your experience, and also the types of housing available to those different types of household, family compared to one person. What's your experience for those housing typologies to provide housing for many different types of family units or individuals?
Well, I think you need to be able to cater for people who are on their own and who have potential disabilities, who have a reasonably mobile at present. You need to cater for people such as Carl and Eva, for instance, in their 30s, basically on a minimum or low wages. they would like to have stable accommodation, and not having to wait for every 9 months or 12 months and try and find some another alternative accommodation as well, which is expensive. They would like to be able to have something which is stable, where they can settle down, which is affordable, where they can actually have a family. So you need to be able to cater for all of those. And that might mean, actually, I might have to say, if you go to places such as Vienna or New York or even Sydney in Australia, you have situations where you have in one dwelling or one apartment, one unit, or I'm not sure, one building, you might actually have a multiplicity of different sizes. So you might have 1 bedroom units or 2-bedroom units, but you also might even have a 3-bedroom unit as well, which can accommodate a family with children. And if you've got facilities close by, such as the lake or parks or something like that, it also means that children can also get out and enjoy outdoor activities as well.
Yeah, thanks, Peter. Do you think the people of Kaikohe want 6-story buildings?
Look,
Probably not.
there's no term called NIMBYism and so on. But
Could you do the same, what you're talking about? Could you, I mean, I know that's the modern sort of approach to planning and the like, but could you do the same as what you're sort of talking about with 3 stories, for example? And 3 stories, you don't need a lift, you can do without a lift.
yeah, but you still probably need a lift if you had someone who had some sort of disability.
Yes.
You know, and needed to use a mobility scooter or something like that as well. So that's.
But would that be more in tune with the local environment of Kaikohe rather than 6?
I think we need to have some sort of flexibility, and certainly 3-story would be more acceptable to many people around Kaikohe, as I said, because of NIMBYism and so on. But I think Kaikohe is rather unique in Northland, especially in the far north, in terms of that. What someone once say to me, without being derivative, I think they basically said something along the lines that Kaikohe is a European middle-class enclave in the centre of Northland. So that has a different perspective than perhaps other parts of Northland.
Thanks. Thank you.
Well, thank you very much again for your submission and your answers to our questions. It's been quite helpful. So thank you again.
Thanks,
Okay, so the next person we have on our list is Alex. Please come forward, welcome.
Share your presentation. And you can just move the back one. Move it through and you'll be able to look at the back here.
Good morning.
Good morning.
Are you just going to read your submission to us, or do you have something to hand up?
So the submission was sent in detail. I have a few expansions on it that I want to highlight, things to highlight to you today. I trust you have actually seen and read the submission as it was put in.
Yes, I've seen it, and if you see me gazing me at my computer, that's because I've got it right here in front of me.
If I was to ask the question, what is the purpose of this meeting today? I'm sure that a lot of the replies would be on the lines of hearing submissions to the district plan. But I think the actual answer is given straight in the resource management act. You actually on the end page. I'm just going to go back on this because it's at the wrong.
Ah, it's at the wrong end. Is that right?
So basically, we are here today to deal with something supporting the purpose of the Resource Management Act. And among the tools to support that purpose, we come through a number of layers, rules, national, regional, and so on, and down to the territorial authorities and the district plan, which has its own purpose, is basically support. It has, in order to do that, it is allowed to set rules, district rules, and those rules can be very flexible. I can rush through them because I'm sure you're all familiar with them. But the district plan is in essence the foundation of the Resource Management Act, on which it sits. So for that reason, if we got the rules effectively on the bedrock on which the district plan is built, therefore they need to be clear and unambiguous. There's been a lot of criticism everywhere about the RMA. But in fact, I believe most of that criticism should be directed against the implementation of the thing, particularly at the district plan level. This proposed district plan is an outstanding example of poor implementation. My submission was directed solely at rectifying some of the issues in order to make the plan workable. I'm not arguing whether we should be on 300 square metres or 200 square metres, 2 stories or 6 stories, to take the last one. The major deficiency in this plan is that while it's got rules which clear down, most of them stop at discretionary. Some go down as far as non-complying, but even where that occurs, there's nothing that says what non-complying should be to a breach it. There are no rules that tear down to prohibit it. And I would like to take one example in the current district plan to show you what that means. If I show you a piece of land in Kaikohe, originally that yellow area was one title, 2,151 square metres. As you can see from the number of lines on there, there are now 10 separate titles. The largest of them has a title that says 198 square metres as a lot, plus 1/10 of 657 square metres, which is the access way. If you take that, we're talking 250. But the rules under which this subdivision was carried out minimum areas, minimum lot sizes. Effectively, you have 600 square metres permitted, 300 square metres, 600 to 300 as discretionary. So how do you put 10 lots onto 2,000 square metres? This is the problem, that as long as you avoid putting prohibitions in, the developer, the experts who will come along and assure the commissioners hearing that, oh, it's less than minor. You all heard that phrase. And we get results like this. I'm not saying that there's anything wrong with that particular development, but I'm saying the rules don't support things. There's another issue on there. There's a building requirement, a residential each allotment, that it's got to have a 14 metre by 14 metre building site. If you think about that one that was on just now, sorry, too far back, you'll see they're all rectangular sections. Well, the largest is 198 square metres, 14 by 14 is 196. So no way can any of those meet the building platform requirements. We also had the issue that, sorry, to that one again. There's a requirement in the current district scheme that any roadway, any subdivision with more than 8 lots, the road must vest to council. We have 10 lots on there retaining their access way. No certainty. That's why my request was for the review of the plan and putting some stops on the minimums. It cannot be done in blanket because some of them have got minimums, some might have maximums, some don't have numbers that are applicable. For certainty in planning, and this will also reduce the large number of applications that come in that do not meet the rules or bend the rules, taking up council time, hearings time, providing employment for some commissioners, but adding to the costs and uncertainty. You've just heard of somebody asking for 6 stories. If that's in the plan, that's accepted. But if suddenly that comes next year, the certainty of that has disappeared. Next item that was for this part of the hearing, I sought to remove specific zoning that was driven by historic resource consents, like Carry Cliff. They have their consent, that gives them all those rules. Why does it need a separate zone, which complicates the plan? And that was just basically brushed over. My third relates to the document as a whole. My submission actually ran to 25 pages, including the preamble bits at the front. The first piece was put out as a brief summary, highlighting the points. In pages 10 to 25 was examples of the problems. And I would just take a couple. I talk about meaningless statements. I've highlighted a phrase on there. This is straight copy of the plan. What does that sentence, where a river is smaller than 3 meters average width, means 10 meters of a river, actually mean? This is a legal document, or will be. Now, there are a couple of possibilities. We could look at the lines higher up, which also talk about the river margins, in which case we would interpret as when a river is smaller than 3 meters average width, it means the area of land within 10 meters of the river. That's something that's not been in any of the definitions of past plans. It's a major change to take all small watercourses and suddenly apply the margin rules to 10 meters of them. Another possibility is it's just a total error, a copy and paste, failing to take out, but I don't know. But consider the impact of making 10 meters around all small watercourses and putting rules on those. Or we have another. If you're struggling to read it, sorry, that's the real one. How about the bird scaring? 7 AM to 7 PM in any calendar year? Obviously, a typo error is meant to be day. There are masses of these sort of errors in it. All I'm asking is that they be reviewed and cleaned up. Now, I put in some suggestions to improve the clarity, highlight inconsistencies, duplications, or typing errors. Well, some of them might be minor, others could be very significant. Mr. Chairman, at this stage, I would like through you for a question to be posed to the author of the Section 42A report. Not unreasonable.
Well, we can pose the question and we'll determine whether we'll ask it, but we can always pose it here.
Right. The question was, did she read my whole submission before preparing a report?
Oh, sorry, officers, are you
Yes,
prepared to answer that question?
not too sure which report it's referring to, the serotonin report.
This is for the section, for the author of the Section 42A.
Sorry, hang on, excuse me, everyone, excuse me. Let's just have the discussion through me.
Sorry.
So, yeah, you've asked me the question. I'll relay the question to council officers. Can we hear a response? Please.
Yes, we have read the submission and we suggested amendments under clause 16.
That's the answer to your question. Now, we're not going to be allowing a to and fro cross-examination here.
Not putting to and fro, I was just seeking to clarify that the whole submission was read.
Yes.
Because a lot of the Section 42A report doesn't address the whole submission or the whole of the parts that we're talking about on part 1.
Can I just stop you there for a moment to say that we're actually dealing with topic 1?
Yeah, I'm talking about part 1.
Part 1, okay. So,
My first point that I raised with you was just dismissed with no discussion of its merits, no indication at all. And in fact, the arguments put forward in that section, covering a number of submissions, suggested the council had spent 10 years drawing up this plan and now run out of time to deal with corrections from this very, as far as I'm concerned, defective plan. That is the part where I'm talking about the errors and issues. And it specifically says that I did not provide specific details of duplications or errors. As I stated earlier, 15 pages were devoted to that. Well, I could accept the Section 42A report referring to the layout errors for correction where they are minor. Total dismissal is unacceptable. That's what has occurred. Well, fixing minor errors is okay, but the example I gave you of the 10 meters of a river, that is not minor. I'm not the only submitter to suggest that their reports have not been addressed fully or in this 42A report. At least 2, I think it was 3 of your expert witnesses lodged the same complaint that issues hadn't been addressed. This actually raises a wider issue. Can you rely on anything in this 42A report? How many other submitters have had their submission arguments discarded? One is tempted to ask if the author's previous role at FNDC was responsible for the original errors, which they now refuse to acknowledge. I consider this report so poor that I will be making complaint to the author's professional body. That's my view of the Section 42A bit, which attempts to essentially discard significant errors. Thank you.
thank you. My comment would be, I don't think your entire submission has been rejected.
No, sorry, I'm talking about the entire piece of the 42A. If you read the 42A in my submissions, they're all basically discarded.
As I just said, I don't think your entire submission has been rejected. I think, and I'll go back and check the 42A report myself. I haven't got it. And there's a lot in that report. But I think what might have happened is that the bit that relates to part 1.
Yeah, I'm talking about part 1.
That, yeah. But I don't think the author of the 42A report doesn't have the responsibility of rejecting the entire submission for which we are other parts of the plan that we're yet to hear.
The issue, Mr. Chairman, is I wrote, and the item 4, or section 4, which was talking about the complaints, was dealt with in about 8 or 9 lines. The last, or the penultimate line said, see Appendix 4 for details. Appendix 4 was the 15 pages I referred to. To say I did not provide examples of duplications, etc.
I get that part of your submission.
Yeah,
Okay, thanks. No, thank you. I mean, you've obviously done a lot of work. And obviously this is the public process. This is where the plan, it gets formulated in the cells of the planners. Now we're in the public participation process. It's 3 phases to that, making further submissions, and then gentlemen like yourself presenting here to say there are still these things that you need to address. And obviously we're going to be taking this all into account. We've got your submission with all your recommended changes. We'll be possibly making further inquiries of the council officers at the conclusion of all the evidence. And then we have the final recommendation report at the end of the process. So your submission will not be discarded. We'll be taking it into full consideration. And I just want to thank you again for being so diligent and trying to identify areas where you think there needs to be more clarity and making suggestions to us.
Yeah, I think you play a great role, Mr. Cox, and you know, we know each other obviously, but I think you play a great role in terms of that public watchdog role that keeping everybody up to the mark. But I think, you know, when you look at that particular sentence that the reporting officer's written, I see a couple of things in that. I see one is that I actually see an acceptance of what you're saying, and I think that the report writer this is, I don't know, I'm interpreting that to say that she's saying we're going to fix minor errors, duplications and numbering on the basis of your submission. And I think there's an interpretation in terms of what they see as minor or not, comes back to effects type things. I think they're probably looking at doing more than perhaps you feel. But the other thing is, there's the word recommended in there, recommend. And it was one of the points we made to one of the expert witnesses that appeared in front of us in the last couple of days, that those are the officer's recommendations, but at the end of the day, you know, we as the decision makers will make the call on that. So it might well be on the basis of what we hear from you that we don't accept what's being put to us in the 42A. It's at our discretion as to how we deal with it. So that's where it becomes really important that you come along, obviously, and make your point. And you certainly make your point well. So I thank you for it.
Thank you, Mr. Cox. And reiterate what my colleagues have also said. We have had other submitters come and speak over the last couple of days, and some of them have said, keep it simple, keep it clear and keep it easy. And what you've talked through today has reiterated a bit of interpretation or confusion potentially. So the question is, what are ways of keeping it simple, clear and easy? Would you have any potential suggestions?
Well, I put something in my submission that there are examples, apart from duplications. There's one case where the same line appears twice. Once is headed somewhere around rural, the next one is headed rural. But they're exactly the same thing. So you do that. The numbering system is inconsistent on use, things like that. It's just a matter of somebody needing to proofread the document. That's what seems to be very lacking in this one. And there's also a tendency in the whole plan that it distinctly appears to have had sections written by one person. These written by another, quite different styles, rather than somebody pulling the whole lot together as one and getting consistency that way. Typos should not be in the document at that stage.
Thank you.
Yes, I have to say, unfortunately, there are many operative planning instruments that still have typos in them.
No,
I mean, one of the things.
spell checkers actually worse because they don't look at the one that's another valid word.
One of the interesting stories about what people put into plans is, as a joke years ago, Wellington City Council, a number of planners, and I'm not saying I was a part of it, I just know of it, and I know you'd know it was me or that had a part in it. They decided to put in a definition of planners. We put in a definition of planners that reads something along the lines are like penguins, and they run together. They don't run by themselves. They run together and they all jump in the water together and they all drown. And somebody forgot to take it out before it became an operative document, before it went before Judge Treadwell. Judge Treadwell was at the Environment Court one day hearing an appeal. He looked up the definition of places of assembly. And below it was this definition, in front of it was this definition of planners. And he looked up from the thing and he said, well, that's an interesting definition. I wonder how that got there. I remember planners got a caning from the city solicitor about what we've done with the plan. So one has to be very careful in proofreading it because you don't know where it's going to end up. And that's an extreme example that a lot of Wellington City Council planners would tell you about.
Well, if you look at the Auckland Unitary Plan and the definitions of the Auckland Unitary Plan and look under B, you'll find there's a definition of vibe. It was put in by, it's now the Chief Justice of the Environment Court, as a joke, and nobody took it out, and it's now part of the operative plan, so.
No, don't point the finger at that.
Now, so thanks again for your submission, Mr. Cox. I assume we're going to be seeing you later on in the hearings to come.
I presume
To other parts of the plan that you
have some other parts in the plan that I've heard nothing back about yet. So
yes,
I
we're
presume
early
you'll
days yet.
see me again. There's at least one of those I would definitely be coming to speak to.
Yes, okay. On that case, farewell till then, and we'll see you again. Thank you again for the submission.
Implications.
Hey, sorry. Right, so I think our next, oh no, I've got a. The next time, the next submitter is the Royal Forest Protection Society of New Zealand, and I believe that you're going to be presenting that online. And who do we have? We've got several names here on the attendance list. Dean Agent Mercer. And
Kia ora, rangatira mā.
okay, so sorry, can we
Tim will be presenting.
Tim's up the top. It's a bit like University Challenge. Tim's up the top and Dean's down the bottom. Okay, who's going to go first?
Kia ora, Commissioners. I'm Tim Williams. I'm going to be speaking to our submission today for this hearing. You'll be hearing a lot more from Dean when we come to the next hearing that we're involved in. I think that's hearing 4, which is to do with the natural environment chapter. And Dean's our regional conservation manager, so he's really an expert in the Indigenous biodiversity in the regions. I mean, if you do have any questions today, specifically, about that, then he's probably the person to direct those questions to. But I'd like to address you, if I may, on the submissions that relate to the structure of the plan and the strategic directions.
Just to clarify, we've got one written statement that's from you, Mr. Williams.
Yes.
And is that the only written statement that we have before us, other than your submission?
That's correct for today, Commissioner. Yes, thank you. There's just some speaking notes which I've prepared, hopefully to assist you. Yeah, I'm employed by Forest and Bird. I'm a lawyer with Forest and Bird. I mean, they aren't intended to be legal submissions, but they're just speaking notes which I've drawn out some of the key issues as I see them, which relate to this hearing from Forest and Bird's submission. I hope that's.
Are you sharing the screen now at the moment?
Oh no, I'm not sharing my screen. I can. Would you like me to share those notes? Yep. Absolutely.
No, we've got them in front of us. So you just looked like you were about to share your screen.
Okay. No, I don't think I need to, but I'm happy to if it assists. So would you like me to go ahead, or would you like a moment to read those notes? So it's difficult to tell when you're not in the room.
So we're not saying this is expert evidence, it hasn't been pre-read, so take us through
Yeah,
them.
absolutely. Thank you. Yes, it's not expert evidence at all. No, they're just speaking notes. So essentially, as I say at the top there, I've drawn out 3 key issues which are relevant to this hearing 1. And I'll just take you through those. So the first issue is to do with the general approach chapter, and this is the question of whether there should be a kind of a hierarchy between the strategic directions and the objectives and policies that you find in the rest of the plan in the other chapters. And we've submitted that there shouldn't be a hierarchy, that really they should all be consistent, ideally, and that if there's any kind of a tension is found between them in particular cases, then you really need to read them all together rather than creating a hierarchy within the plan, which I've suggested isn't supported by the Resource Management Act. So this submission was considered in the Section 42A report, but I'm not sure it was fully considered because it was considered in the context of the strategic direction chapter, and the council officer agreed that this kind of wording, which creates a hierarchy, or certainly appears to me to create a hierarchy, should be removed from the strategic direction chapter because it duplicates what's in the general approach chapter. But then the Section 42 report for the general approach chapter didn't actually consider the substantive submission. So I'd ask you please to consider that when you're making your decision. And essentially what we're proposing is a different form of wording, which has been supported by the Environment Court in the case that's referred to there. I sent a copy of that case to your hearings manager, Alicia Kate, and so that will be available for you if you feel you need it. But the form of wording which appears in paragraph 3 of those speaking notes on the second page is the wording that was taken from that Environment Court case. And you'll see that it, if you look in particular at this B at the end of paragraph 3, it says that the relevant objectives and policies of the district plan are to be considered together and no fixed hierarchy exists between them. So Forest and Bird's submission is that that's the appropriate form of wording which should appear in the general approach chapter, which describes the role and function of the strategic directions. I mean, essentially, the risk is that you could have the strategic directions are very broadly phrased, and what you don't want is to have specific policies which have been carefully thought out in other chapters being overruled by a sort of an interpretation of a very broad provision in the strategic directions chapter. So they should all be read together. I hope that makes sense.
Tim, can I just interrupt you there and ask a question? I'm just a bit concerned that we'll lose, some of the momentum or some of the detail as we move between two folk. But, you highlighted part B of that provision. You've said that the Environment Court brought that down, which is a little bit surprising because I think it's a bit loose in the wording. And I think at A, where it talked about the strategic objectives may provide guidance, I'm surprised they have the word may there. And I thought as a lawyer, you'd pick up on that more than me. But I mean, the fact is, that seemed on the face of a good idea to expand on just how the strategic directions and the objectives and policies relate, because we've heard other people raise that in these hearings, but just surprises me that the word may, I mean, at the end of the day, the strategic direction does provide guidance. It's not a may.
That was actually specifically considered by the Environment Court, and the word may was recommended in that case. I mean, I appreciate all the plans are, prepared, in their own context. But yeah, that is a point that was considered by the Environment Court. I mean, my understanding is that, you're going to have strategic directions on which apply to in different ways, and they may or may not provide guidance in any specific case. I mean, you need to look at them, but it may be that some of the strategic directions are not relevant to a case which is being considered, you know, on a particular application, for example.
That's always the case with
Yeah.
any form of objectives. I mean, some are more relevant than others, but yeah, I'll leave it at that. But it just
Okay.
seems to me that the wording's a little bit loose, which is surprising. But then it wouldn't be the first time we fell foul of the Environment Court.
Well, I can't take responsibility for the wording, as I say. It's been, yeah, it has been taken from that Environment Court decision, which was referred to in the submissions. So
Can I just jump in there too and just say, I share Commissioner Watson's concerns, and we've had quite a bit of evidence already at this hearing about, you know, the strategic direction being the engine room of the district plan. And if it is the engine room, we don't have may. You should, you know, all those submissions should be relevant and taken into consideration. Now, whether they are necessarily determinative of any particular application, that's for a planner to determine. But yeah, it seems to me if this is the engine room, then strategic direction.
It's a good point. I think that obviously the strategic directions are very important, and it's very important that they are consistent with the rest of the plan. So I think if you are minded to sort of use wording that's a bit more directive, then I suppose my suggestion would be that this is returned to after all of the other objectives and policies in the plan have been considered in detail in the different hearings, just to ensure that the strategic directives are in fact consistent with what has been determined in relation to each of those chapters. Because what you don't want to have, I would suggest, is a situation where you do have strategic directives that are in conflict with the provisions elsewhere in the plan, and then a hierarchy which requires decision makers to apply the strategic direction, not the provisions in the other more specific chapters.
Okay, thank you for that.
Okay.
Continue. Or have you finished your presentation? You've got more to say?
Oh no, well that's issue 1. Yeah, there's 3 issues.
Yeah. So I think we're what, at issue 2?
We're now issue 2 now. Thank you. So issue 2 is the inclusion of water bodies in the in SD. I'll use SDNE 05 because I think that that's the suggested change to avoid confusion. So we're at paragraph 10 of the speaking notes now. We've requested an amendment to that strategic directive to include reference to water bodies. And the reason is that water bodies appears together with the coastal environment in section 6 of the RMA, matters of national importance. So they're treated together in that section. And it's not clear why council has chosen to exclude water bodies from SDNE 05, which refers to the coastal environment, protecting the natural character of the coastal environment. So there's an explanation for this provided in the section 42A report, which is that the intention is to identify and respond to the resource management issues that are considered to be of particular importance in the Far North District. And I would suggest that surely water bodies must be of particular importance in the district. And that is in fact reflected in the proposed provisions elsewhere in the plan. And I've referred particularly to the Natural Environmental Values chapter, NATC Objective 1 and Objective 2. And in fact, that whole section of the proposed district plan is devoted to water bodies and their margins. And you know, the other sort of rationale for not including water bodies was that it's not in, well, it referred to the long-term protection for future generations. And again, I'd suggest that the protection of water bodies and their margins is certainly important when it comes to ensuring you know, the welfare of future generations. So overall, Yeah. Forest and Bird believes that it would be incongruous to not recognise the importance of water bodies and their margins in this strategic direction objective. It's not clear why it's been excluded, and I think there would need to be a good reason to exclude it, as opposed to, well, there are certainly good reasons for including it, I would suggest. That's issue 2. So I don't know if you want to, I'm happy to take questions on that now, or if you have any, or after I've dealt with issue 3.
Yeah, and I think we'll continue to issue 3
Yep.
and then what questions pop out after that.
Thank you. So issue 3 is the inclusion of Indigenous biodiversity in the strategic direction objectives. So the first is possibly just a sort of a drafting point, I'm not sure, but we do support the objective SDNE06, which relates to SNAs, but we're suggesting that the objective should be amended to read identified and protected. So SNAs should be identified and protected. And that was raised in our submission. The Section 42A report didn't really consider it. It just dealt with the typo that was in the proposed district plan. I think it said it was the word "and," I think was there, but it was a sort of it didn't read properly. So there's been a suggestion, or it's been recommended that that be amended, but the inclusion of the word identified wasn't addressed in the Section 42A report. And in my submission, it should be, that wording should be there. It would be consistent with the objective IB01 in the ecosystems and indigenous biodiversity section, which does state that SNAs should be identified and protected. So yeah, I would suggest that it would just be better for the plan to be consistent in its use of that wording. And so the words identified and should be added in the strategic directions chapter. We've also asked for a separate or additional strategic direction, which specifically relates to, Indigenous biodiversity outside SNAs. So it's not only within SNAs that we should be concerned about protecting and enhancing Indigenous biodiversity. We should be trying to do that, across the board, really, where possible, and a strategic direction to reflect that would be appropriate, I would suggest. We've also sort of, perhaps in a way as an alternative, you may find, we've suggested including reference to Indigenous biodiversity in the urban form and development and the rural environment strategic objectives. So the Section 42A report looked at that and found that this is for example, at paragraph 175 of the Section 42A report, the council officer found that that would be better addressed in the natural environment strategic objectives. So in order to do that, you would need to put an additional strategic objective into the natural environment section, right? So that's what we're asking for. And that covers off the issues that I wanted to raise with you today. Thank you for hearing me, and I'm happy to take any questions.
Okay, thank you.
Yeah, it's interesting when you say identified. I'd suggest it needs to be almost say identified with accuracy, because as a commissioner sitting on applications relating to SMAs and the like, invariably witnesses bring up problems with the identification, that they're not accurately shown. Meant to follow the ridge line, but it doesn't. It's halfway down the ridge line, and unfortunately the importance of the SNAs is sometimes lost because of a lack of actually identifying them accurately in district planning documents. So it's only a practice thing, but we have to be sure that they are accurately depicted, and they should be, with modern technology, quite frankly. But just to comment on that.
Well, I certainly agree with that, Commissioner. Yeah, I think perhaps that supports my argument that you know, the need to identify them should be emphasised.
Thanks.
Thank you for your summary. That's really helpful. And into the 3 issues. Just a question about SNAs in the context of the Far North. Are you aware about our district and that we have a lot of Māori land?
I am aware of that, Commissioner. I'm anticipating that this may be a question that that Dean might be better placed to answer, but I'll wait to hear hear where it goes. I am familiar with the district. I did live in Kaikohe for a few years, but it's not my area of expertise, I would say. Yeah.
Yeah. Thank you for your response. Are you aware that we had a march of 5,000 people down the Kaikohe Main Street here? I was one of the councillors that had those 5,000 people screaming in my face. And definitely memorable about the views of the district, in particular, very strong views from mana whenua and a lot of farmers that were both there together in that march. I'm not sure if you're aware of that event that we had here in the Far North. Were you aware of that?
I'm aware that there's been quite substantial opposition in the Far North to SNAs. Is that, as I say, probably better addressed to Dean potentially. But yeah. What is your question? I am aware of the opposition. Yeah.
So I think of what I'm asking about is clause 18, where it's underlined identify. A lot of the feedback that we had from our community was about drawing lines on their whenua and identifying restrictions when the Crown had made many pieces of legislation to legislate away not only what they can do on their whenua, but also even the ownership, you know, of their whenua. So definitely pushback that we heard about putting further restrictions on land that people can't lend against. You know, people don't have housing, you know, further restrictions, and in this case, you know, with the identifying of regulatory frameworks around whenua was one of the big responses that we had. So that's why I just wanted to raise it in the context of number 18, and if you're aware of that feedback about that word being included and proposed in the context of the Far North.
Well, Commissioner, I think that, you know, for SNAs would have to be identified if they're going to be protected. I have talked to Dean about the way in which this has been communicated by council, and I think probably more work needs to be done in order to explain to people how these provisions could be to their advantage, as opposed to being seen merely as a further restriction on their, you know, rights as landowners. But it's look, if you're going to protect SNAs, then I think, you know, you clearly are going to need to identify them, and that process of identification is one which should be sensitive to the views of landowners. It should engage with landowners, of course, and I anticipate that is what's going to be attempted, at least. I don't know if Dean has anything. Dean, would you like to add something on this? I know it's something that you have thought a lot about.
Yeah, look, I'm really sorry my connection dropped out there, so I missed part of what you were saying, Kelly. Yeah, at the time when the SNAs were identified, myrtle rust had just come into the country, and so there was a stipulation that all threatened species were to be included in SNAs. And because it looked like myrtle rust was going to affect manuka and kanuka species, all of those areas with those species were included. And so in our submission, we think there should be two tiers for significant natural areas so that the significance is really clear. And that's why they need to be identified for those last significant ancient forest remnants, wetlands and so forth. And another tier for very early regeneration, which all got lumped together. So we'll probably go further into this in a future hearing, but it is really important that the biodiversity of the North is protected and landowners get to learn also about what's significant. Like where I'm living now, where I'm beaming to you from at Otangaroa, there's an endemic gecko that lives only between Kaikohe and Hokianga, and that's here. And if people don't know, they don't know what they're looking after and that they are custodians of.
No, I don't have any further questions, so I think that's all the questions from the panel. So again, thank you very much for your submission and your statement. We will, and we will call it analytical submissions, and your answers to our questions today. You've given us plenty to think about. I'm sure we'll be seeing you again in subsequent topics on various chapters of the plan. So farewell, and we'll see you again later on in the process.
Thank you,
Kia ora.
Commissioners. Thank you. Kia ora.
Kia ora.
And we next move to Thomas Travilla. Have I pronounced your name correctly?
Mr. Chair, it's Trevilla.
Travilla.
Yes, that's correct.
And you're here representing the fuel companies.
Yes, that's correct. Good morning, Mr. Chair, Commissioners, and the members and officers of the Council. I think we can just start with some brief introductions. My name is Thomas Trevilla. I'm a planner at SLR Consulting, presenting evidence on behalf of the fuel companies, which comprises BP, Mobil, and Clean Energy. On this submission, and specifically point number 6 in the request for a contaminated land chapter. As I informed the hearings advisor last week, a colleague of mine on the SLR planning team will also be joining, Ms. Westerby, Ms. Sarah Westerby.
Kia ora koutou.
Morning,
My
welcome.
name is, good morning. My name is Sarah Westerby. I'm a principal planner at SLR. I, on behalf of the fuel companies, I prepared their submission to the PDP. Kia ora.
Mr. Chair, I've asked Ms. Westerby to join me today, given her experience with both consenting and policy services to the fuel companies. And during the Q&A, she might be able to provide additional input or answers that the panel may find helpful. And yes, so with my evidence taken as read, I've prepared a summary statement, which I sent to the hearings advisor yesterday afternoon, and hope is available to the panel, and I'll just be speaking to that statement. Should take a few minutes, and afterwards we can take questions.
Yes, we have your summary statement here. So everyone's got that summary statement? Yep, so we have it here. So take us through it, please.
Thank you very much. So the fuel company's submission supported the PDP's approach of relying on the rules framework of the NES for contaminants in soil to protect human health, but expressed concern over the absence of a complementary contaminated land policy framework. The submission requested a chapter and proposed an objective in 2 policies to provide a brief but targeted policy framework to assist the assessment of applications requiring consent under the NES. The reporting officer, Sarah Trinder, recommends the submission's rejection. My understanding of this recommendation at paragraph 181 of her report is that she doesn't support the principle of a chapter and considers that the NES should be relied on to, quote, avoid duplication in process and potential inconsistency. I disagree with Ms. Trinder's recommendation, and in forming my opinion, I turn my mind to 3 broad issues, which I analyze in my evidence and just briefly summarize as follows. So the first issue is really a matter of scope and context, being the function of territorial authorities in relation to contaminated land under the Act and NES. So the Council's functions under Section 31 of the Act include the prevention or mitigation of adverse effects from development, subdivision, or use of contaminated land. And the NES provides nationally consistent standard and rules to manage the specified activities on land, which may be contaminated in such a way that poses a risk to human health. The NES seeks that contaminated land is appropriately identified and assessed, and, if necessary, remediated or the contaminants contained to ensure that it's safe for its intended use. The NES only relates to territorial authority functions, and the Council is required to observe and enforce the NES under Section 44A. So taking all this into account, I consider that having a clear policy and rule framework is within the scope of, and is important to achieving the Council's function under the Act and NES. Now, the second issue is whether a contaminated land chapter will result in duplication in process or inconsistency. So firstly, in terms of a duplication in, quote, process, I infer that Ms. Trinder's concern relates to the resource consenting process. In that regard, I see no duplication with consenting under the NES if the chapter doesn't contain any rules. Secondly, an appropriately drafted chapter will not duplicate or result in inconsistency with the NES. This is because the NES doesn't contain any objectives or policies, and as such, a PDP policy framework would complement its rules framework. I also know that having a contaminated land policy framework isn't unique among the new generation of district plans. Paragraph 6.10 of my evidence cites operative plans across New Zealand that apply the same approach. In Northland, this is applied by the Whangarei District Council in its operative plan, and based on its draft plan, the Kaikohe District Council intends to apply it as well. And thirdly, while Ms. Trinder's recommendation didn't discuss regional planning instruments, I also consider that a chapter will not conflict with those of the NRC. Now, this is because the regional policy statement doesn't contain contaminated land provisions, and the regional plan provisions reflect the NRC's responsibility for a different aspect of contaminated land management, being the investigation of contaminated land for the purpose of identification and monitoring, and managing the adverse effects of contaminant discharges on the wider environment, including the natural environment, such as soil, water, air, and ecosystems. Paragraph 6.16 of my evidence sets out the characteristics which I consider are reflective in an appropriately drafted chapter, and I considered these when I drafted the relief recommended by my evidence. Now, the third issue is whether contaminated land chapter will assist the assessment of applications requiring NES consent. Policy analyses are important for all applications, but it's particularly important for those of a discretionary or non-complying activity status. In terms of the latter, my evidence recognizes that as the NES doesn't contain non-complying activities rules, the status in the case of the fuel company's activities would likely arise in more substantial service station works that may have a range of consent triggers and may include a non-complying rule under the district plan. As the panel is aware, a policy analysis is a critical limb of the Section 104D gateway assessment for non-complying activity, and more broadly is an important limb of the Section 104 assessment for any activity. So without a contaminated land policy framework in the PDP, a gap is created when undertaking these policy analyses, as there's no NPS for contaminated land, there's no contaminated land objectives or policies in the RPS, and there are no objectives and policies in the NES. So applicants in the council could thus only look to the intent of the NES based on their understanding of the regulations and explanatory note, which doesn't necessarily represent a clear nor consistent or formal policy framework in comparison to objectives and policies. Therefore, I consider that a contaminated land chapter will avoid this policy gap and assist their assessments. So in conclusion, my view is that having a contaminated land policy framework in the PDP is within the scope of and is important to achieving the council's function in relation to contaminated land. Isn't unique, as operative district plans across New Zealand have contaminated land chapters that take a similar approach, including the Whangarei district. If drafted appropriately, will not result in a duplication in process or inconsistency with the NES or other planning instruments, nor conflict with the council's duties under Section 44A and the contents and sort of the function of district plans under Section 75, and will assist both applicants and the council in assessing applications that require consent under the NES, particularly with their policy analyses. Paragraph 7.2 of my evidence recommends the insertion of a chapter, and the recommended provisions consist of a chapter overview, an objective, 2 policies, and a brief rules footnote that there are no additional rules in the PDP. The submission didn't include an overview, and I've recommended one to be in line with other PDP chapters and the general drafting of plans, and so that the resource management issue and provisions are contextualized to plan users. The recommended objective and policies are identical to those in the submission, except for some minor corrections that I've outlined. And pursuant to Section 32AA of the Act, Appendix A of my evidence contains an evaluation of my recommended amendments where I considered the appropriateness of the objective in achieving the Act's purpose, the appropriateness of the policies in achieving the objective, the anticipated benefits and costs of the recommended provisions, and the risk of acting or not acting. The evaluation supports the recommended amendments. Thank you very much, and I'm happy to take questions from the panel.
Yeah, well, thank you very much for a very focused summary. And also, thank you very much for taking the time to actually writing some provisions for us to consider. So just to confirm, you're looking for this chapter to have objectives and policies only and not any further rules?
Yes, Mr. Chair, that's correct.
And that's because there's no objectives and policies in the National Environmental Standard because it's a national environmental standard.
That's correct, Mr. Chair.
Yeah, and I think what your evidence was saying is that when you're possibly presented with something like a non-complying activity and you're assessing under 104D, 104DB, you want to have some relevant objectives and policies to refer to.
That's correct.
Okay, I follow that logic. And I have to say, it's not often I see planners for fuel companies coming along to hearings asking for more provisions to apply to them. So definitely you and your clients should be commended for that aspect at least. So just to confirm, no further rules. So you would be guided by the NESCS for all those rule parts. It's just the objectives and policy framework that would guide your evaluation under those rules.
Yes, that's correct, Mr. Chair.
Okay, no, thank you. That clarifies everything for me. I'll see if the other commissioners have any questions.
Kia ora. Interesting that we may need a policy like this. Is your company considering buying land for this kind of disposal?
Sorry, by company, do you mean the fuel companies?
Sorry?
What do you mean by company, Commissioner?
Yeah, in regards to your submission, would your company be considering buying land for, dealing with contaminated tanks? I think to have a submission, but it's also the practice. And so for me personally, I'd be interested, where would those sites be that would be safe for other people? If you understand what I'm saying. Do you have a site in mind in the far north?
In terms of my company as a consultancy, we consult with the fuel companies. In terms of the fuel companies' operations.
Yeah, I think perhaps I'll just say a couple of things. Kia ora, Sarah here. So the fuel companies operate, we're really talking about maintenance and ongoing operation at existing service stations. That is their real interest in the far north at this stage. So it's really about when they're needing to undertake maintenance and fixing of things requiring earthworks or soil disturbance. So it's not really about future investment in new sites or but it is about disposal, if that's where you were going, of potentially contaminated soil. But it's got nothing to do with the purchase of land in terms of their interests.
That's why I would be interested in, if you took this policy a little bit further and that the Far North District Council adopted it, then there needs to be a site for, well, I'm assuming that you're asking to bury old tanks or something. Not just fixing up. So when you upgrade tanks in a garage, you take away the old tanks and then you put in new ones.
That's
So
correct.
that would be like a burial site for old tanks.
Oh, right. In terms of the in terms of the disposal of tanks that have been decommissioned and removed from a site, for instance, where those tanks go is probably outside of the scope of this discussion, because that's not really about the contaminated soil and risk to human health. That's about the disposal of a disused tank. I'd say that's probably one, a work safe matter, a has no hazardous substances and new organisms matter, and thirdly, a matter for the companies and potentially landfills, but slightly outside of the discussion that we're here today, which is about the potential contaminants in soil.
So I sort of took it that for us to have a policy, which I'm okay with, then there obviously needs to be a site somewhere, and that would need to be identified in our plan if there was anything in that sort of direction. That's all. You wouldn't have a contaminated site unless you were going to a policy about getting rid of contaminants, unless you had a site in the far north. Otherwise, we wouldn't bother about it.
Fair enough. Okay, so I can give you a live example, if that might help.
Yeah.
Yep. Z Energy has approached me to install some electric vehicle charging equipment at Z Taipa. And that will involve some earthworks to install some underground cables and to install the kit, basically. Given the scale of the works, it may be that a consent is required under the NES. And so there'll be a couple of activities associated with that. It will be soil disturbance and potentially soil removal. Where that soil goes I actually don't know where it will go. It will go to an appropriately licensed disposal facility. And on site, the works will be undertaken under WorkSafe requirements and NES requirements. So that's a practical side of things, as an example of where that consent is required. If we're going back to the assessment, it is helpful to have policy direction.
I also hear that other people want other places other than Taipa need electric charging things, but that's another story. Okay.
Okay. Thank you.
Thank you.
Is it Taipa?
I think it's a fair question because it's a fair question because it rounds off that particular provision, and it might be something we have to have a look at as a consequential amendment or the like. And it might be, as you're suggesting, that it's it's dealt with like the hazardous substances legislation or the like, and obviously on applications, if there is contaminated soils or the like, where are those soils going to go? And it's a fair question to ask, and it might be something we need to respond to as part of yours. But I'd just like to say that was a very clearly written submission and very clearly and well expressed. So thanks for that. Just the question, I suppose, that comes out of it is that how does what the relief you're seeking relate to the Whangarei example? I haven't looked at the Whangarei example, but I'd suggest it's probably more widely, encompasses more. If we had a look at the Whangarei example, is that something we should look at in the context of deciding on your submission?
So the purpose of me listing those operative plans was really just to show that the general intent of the relief that the fuel companies seek in terms of having the complementary policy framework for the NES isn't necessarily unique. And in doing just a survey of different plans across New Zealand, I identified that Whangarei also takes that same approach. And I think the Kaikohe draft district plan will also do that at this stage. In terms of how I drafted my recommended provisions, I took into account the characteristics that I set out in my evidence. I had a look of how these other chapters were drafted in terms of operative examples. And I sort of drafted that in the context of, customizing it for the district, identifying the functions of the FNDC and NRC, and also having regard to how other chapter overviews and the PDP are drafted, it tends to be a bit more accessible than some of the other plans in terms of their choice of wording and a bit more simplicity. And I've tried to match that. In any case, the recommended relief shows the intent of the relief sought. And we're happy to refine it further if you would find that helpful, and to work with the council as well.
Okay, thanks very much.
Right, no, thank you very much for your submission, your summary, and your provisions that you provided us and the answers to our questions.
Thank you to the panel, and no further questions.
No further questions.
Thank you. I look forward to seeing all of you guys in subsequent hearings. Thank you very much.
Thank you.
Okay. And if we have one more submitter, that being Transpower. I'm assuming for the Transpower.
Yeah.
What I'm going to come up here and make yourself comfortable. I'm going to give us a 5-minute adjournment, only because I need it. But everyone else can take advantage of it.
Thank you.
So just chill out for 5 minutes.
Using the room.
muting the room.
Thank you for allowing me to.
It's fine.
Turned out that being stretched out to a slightly longer break, so I'll pull the hearing back into order. Welcome. We've got 2 statements of evidence from you. Do you have any written summaries you want to distribute? We're going to take your evidence.
Yes, thank you. So I can give a brief summary of what my evidence and pass on to Ms. Dines if that works.
That's fine. We had pre-read your
Yes.
evidence, so feel free to just summarise it for us and refamiliarise us. We've read a lot of evidence.
Yes. We understand, sir, yeah. Tēnā koutou katoa, ko Rebecca Eng Kapuinua. My name's Rebecca Eng. I'm Technical Lead Environmental Policy at Transpower New Zealand Limited, and I'm an planner. And I'm joined by Ms. Sharon Dines, who's our expert planning witness today. Thank you for having us here in Kaikohe today. We have a confined, as you may recall in our evidence, we have Ms. Dines' evidence, a relatively confined number of measures outstanding between the Section 42A recommendations and Ms. Dines' opinion on those points. So really, we've come here today to introduce Transpower and ourselves in the National Grid context, foreshadowing our appearance at future hearings on matters of detail. So Transpower is the state-owned enterprise that plans, maintains, owns and operates New Zealand's high voltage electricity network. It transports electricity from where it's generated at hydroelectric dams, solar farms and wind farms to where it's used, whether that be to direct connect customers such as Glenbrook Steel Refinery or Tiwai Aluminium Smelter, and primarily to homes and communities, well, to distribution companies where it's been used in the distribution network by homes and communities. Transpower, so the National Grid is nationally significant infrastructure, and Transpower itself is heavily regulated by the State Owned Enterprises Act. So it works within legislative constraints and delivers that electricity around the country. The assets in the Far North District are relatively confined compared to some other regions. We have one transmission line that extends from Maungataupiri substation up to here in Kaikohe, but Transpower doesn't own the substation itself. It used to, but it was sold to Top Energy some years ago. In terms of plans or projects within this district, Transpower doesn't have any specific plans or upgrades for the Kaikohe to Maungataupiri line at present. It's in the coming year at least, it's looking after that line by carrying out insulator replacements and usual operation and maintenance activities to keep the line going. In the broader context of I suppose, Transpower's strategic directions or priorities, you will all be aware of the Climate Change Response Act 2019, which sets the domestic policy for carbon zero for New Zealand, that goal. Transpower's done a lot of work to look at how that might influence or impact on the electricity network in New Zealand and how electricity demand might increase in the coming years, and also how the grid, in terms of its role within the system, will need to assist meeting that target. And the current prediction is that the demand for electricity is to increase by 68% between now and 2050. And what that means for the national grid is where Transpower needs to look after the assets that it already has so that it can make the best and most efficient use of those assets. And it needs to be prepared to build new connections to new renewable electricity where that might occur. And it also needs to ensure there's enough capacity within the system to enable electrification of process heat, for example. And with that view in mind, I suppose, given Transpower operates, or the National Grid operates within an open electricity market, Transpower doesn't determine where the new renewable electricity will be generated, but it's required to enable connection of that generation into the system so that it can be used. So there's some level of unpredictability in terms of where it may need to build new assets in the future to enable that generation. So, and also given the grid's presence throughout New Zealand, Transpower participates in local authority plans nationwide, primarily to ensure that the national policy statement on electricity transmission is given effect to in plans and policy statements that really fulfill three functions. First is to recognise the national significance and importance of the national grid to social and economic wellbeing and cultural wellbeing. The need for the national grid to be protected from inappropriate subdivision use and development, and the need for consistency in terms of enabling the grid to be developed in the future. So without delving too much into the planning as an in-house witness, you'll hear more from Ms. Dines in coming hearings about the extent to which the provisions as recommended through the Section 42A recommendations give effect to electricity transmission. So really that's the summary of my introduction for Transpower, and I'm happy to take any questions before we move on.
Yeah, no, thank you very much. It's quite helpful at this early stage of the hearing to have you here and just help set the scene and give us the context. Yeah, I got from your evidence that there really wasn't too much in contention in terms of the objectives and policies in part one. But I think it's really worthwhile having you here, as you say, setting the scene, and we'll be seeing you again. So I don't have any further detailed questions in that regard. So I think we could possibly move on to your evidence as well.
Sure. Tēnā koutou katoa, for Sharon Dines Topuinga. I'm, as Rebecca said, the planner, independent planner for Transpower. I am based in Auckland, but I grew up in Manukana and Warkworth, a bit further south from here, and had relatives in the north, including an aunt and uncle that live at Huhora. So I'm reasonably familiar with the area, although I would by no means call myself a local. In terms of, as the chair said, I don't have too many issues at all with the part one of the plan. I think that given the way that e-plans are evolving and the way in which this plan in particular, the various different chapters work together, I think it's very important at the front end of the plan and how the plan works section to give as much clarity and direction as possible as to how to navigate the plan. And so my only real concern is that there are a number of overlays and different sections of the plan that may or may not relate to a particular activity that a farmer or a layperson or somebody coming to the district to do something that may apply to their activity. And I just think it would be very helpful to have a bit more information in the front section of the plan to explain how the plan works. So on page 4, after paragraph 17 of my evidence, I've just inserted a suggested wording there. It just goes over the page a little into page 5. It's not entirely my words. It's actually borrowed from the New Plymouth District Plan, which is has a similar section in it. So I can't take full credit for it, but I just think that would be potentially helpful to go in between where the general approach section starts. Sorry, at the end of the classes of activities sections. I'm completely open if you decide you think it needs to go in a different place in particular, but I just think that direction of how, a little more direction as to how the plan works and where to look for wayfinding notes and things like that within the plan would be really helpful. And I guess in terms of getting to that point, I looked at the plan as if I was a farmer, potentially building a building underneath a transmission line that was owned by Transpower. And I don't think it's particularly easy for that farmer to determine that actually, he might need to talk to Transpower or perhaps avoid that area under the corridor, depending on the uses of that building. So that's the example that I used in order to try and navigate the plan. And I just think a little bit more clarity would be helpful. So that's all I really needed to say about that. And then the other it's a minor concern, but I think it's important again, giving clarity. The Ministry of Education has sought the inclusion of the term and the definition of additional infrastructure, which comes from the NPS for urban development, as you well know. And I don't have any problem whatsoever with the need for social infrastructure like schools to be provided for in the plan. I think that is, absolutely necessary. I'm a planner for infrastructure organisations, and I have, I could talk for hours about the need to make sure that there's infrastructure in place. But that particular definition of additional infrastructure includes reference to lines, a network operated for the purpose of transmitting or distributing electricity or gas. And so because you've got the additional infrastructure definition, the regionally significant infrastructure definition, and in the Act, the definition of infrastructure, then Transpower, the national grid effectively is referred to by 3 different definitions. And I think we just need to look carefully about how those words are used throughout the plan, or those terms are used throughout the plan, to make sure that we are referring to the thing that we need to be referring to. And I did make a suggestion that perhaps social infrastructure might be a better option for referring to schools, but I mean, I'm not the planner for the Minister of Education, so it's not necessarily my place. But yeah, that's the concern, and so I don't seek any particular changes, but I just a word of caution to take care when you're using that definition. And that's really all.
Yeah.
I have.
I don't have any sort of specific questions, but just really to understand the relationship between Transpower and other power generators. So the thing in your evidence, you had that nice figure 2, which showed the line coming from Auckland going up to Kaikohe and it's got top energy written underneath it. Obviously, power lines go all the way up to Cape Reinga. So does Top Energy manage the rest of that network, does it?
Correct.
And that's at a lower capacity, are they lower capacity lines from that point?
That's right, yeah. So Transpower, the national grid voltage up to Kaikohe is 110 kV, or from Kaikohe. And from there, all the lower, the voltage is reduced at the Kaikohe substation, and at least at that location, where it's distributed on the distribution lines that are in the.
Yes, and we had them yesterday and they put up their map, which just showed everything.
Yeah.
So now we know which bits are under your management and which bits are under their management.
If you think of it as the state highway for electricity,
Yes.
the Top Energy is all fine.
Right, yeah, that's right. Arterial and local. Because I think,
Sorry, yes.
yeah, because yours the highest voltage and then there's 2 other voltages, isn't there?
Not in far north. Yeah, I don't know the voltages of the Top Energy network, but they're probably between around, I don't know, 33, 11 kV.
Yeah,
33,
that's right.
down to 11.
Yeah, there's 33 and 11.
Here's Matt.
Okay, thank you. I think Commissioner Watson has some questions for you.
Just a question for you, Sharon. That business of the social infrastructure, such as schools and healthcare facilities, I mean, that's included in the definition now, isn't it, of additional?
Additional infrastructure, yeah.
So do you see that social infrastructure, I mean, do you see that D, that part D just being pulled out on its own, or do you see social infrastructure completely replacing additional infrastructure? I just wasn't clear on that.
I thought that what the minister was looking for was for schools to be included. So, I mean, this is where the careful navigation of what the words mean. So you probably need to see what it looks like with social infrastructure in there instead. And it may be that most of those other things, land transport is also infrastructure. Network operated for the purpose of telecommunications is also infrastructure. A and B are probably not infrastructure, and D definitely isn't infrastructure. And I'm aware from previous work with the Department of Corrections that the prison won't fall within infrastructure, but it would be social infrastructure. So then I think there is really only the gap of A and B, so public open space and community infrastructure, and whether or not that needs to be included in the locations that the minister is seeking to include additional infrastructure, I think.
Yeah, I think it's just, I'm just not quite sure what the ministry is going to get, I suppose, and that's probably the problem we've all got. But it just seems we don't really want to have a definition of social infrastructure that then includes social infrastructure.
Yeah.
Because obviously the definition defines the term. But I mean, if you took social infrastructure out and just had schools and healthcare facilities.
That would work as well,
community infrastructure, obviously it's defined in the Local Government Act, so we're sort of bound by that, I guess, if they've used that as such. Okay, that's fine, thanks. Yeah, we have heard from Top Energy as well.
Thank you. Hello, I'm a local councillor here on the panel. I just had a query in relation to the operations of Transpower. Our community owns Top Energy, but Transpower, in particular, the link from Auckland, which is a very fast growing area, to far north, which is the most beautiful area in the whole of the country, but not as fast growing. So what interests me was your background, that you weren't planning over the next 10 years to do any particular, large upgrades apart from any of the maintenance. And our Top Energy, big new power plant with our geothermal energy has been established here now. And I'm not sure of the amount of power that it can generate, because we pay a lot of money to have that connection from Auckland up. And I don't know what we're paying as a community in the far north to have that privilege based on how much energy we're generating up here by ourselves now with all of our additional solar farms that we've got in the very far north, geothermal down here. So I think just some more context around forward planning for growth, if I can indulge with you being here from Transpower, I've never had someone in our district about that. Just some background about that context and forward planning for our district and planning for growth for our infrastructure, for our forward planning, and how that relates to your plans as Transpower from the big city of Auckland, and linking it up here, because we do pay for that privilege, is my understanding.
I probably have to preface this by saying I'm an environmental planner in the system planning team and don't have a detailed understanding of transmission charging. So I'll be hesitant to sort of stray into those areas beyond the case. all I am aware of in terms of the situation with electricity demand and supply for the Far North District is that currently the demand outstrips the available generation within the distribution network, or at least the available generation within this region, at least the the Northland region. And as you'll recall that figure, evidence that for transmission planning purposes, Transpower looks at Northland as a whole with its own boundaries. And so what that means is, yes, there is some level of local generation that helps support electricity demand, but there's a shortfall which is brought up through that transmission line up to Kaikohe. And as so far as how that impacts on local transmission charges, I can't comment because I don't know the answer, I'm afraid. However, we will be back, and I could assist to the extent that that information can be, I assume it can be shared. Should you want it as a follow-up from this hearing or to provide a future hearing, no doubt appear again. But I hope that helps in the meantime.
Yeah, just saying that Auckland's important, but we also.
Yeah. I mean, I guess the lines, a lot of the upgrade work that was done through the 2000s was with a view to make sure that, given the fact that electricity supply to the Far North primarily comes from generation in the central North Island. And so a lot of the work that was done to upgrade the network through Auckland and the central North Island through the 2000s was with a view to improving the resilience or securing the resilience for both Auckland and Northland. So that project work was done with that in mind.
That context.
Yeah.
Kia ora. I've only got one question. It's probably outside your brief. I think our communities in the Far North are suffering. High deprivation, and even people on middle income are finding it tough. So I was just wondering if there was any steps in the Far North to reduce energy bills, I suppose.
I can't answer that, I'm afraid. So what I understand is that the cost for transmission forms part of your electricity bill, along with the cost from the retailer and the cost from distribution, and the extent and the methodology for charging for transmission, at least, is worked through in a document.
Just that I read the consumer reports about the high profits, the daily profits from power companies, and it's just shocking. But anyhow, that's just something that I think that all of the Far North, our job as the council is not just to worry about a few little things inside our dominion, but also what else can we do to, help in making life easier. And the things that are really dealing to people at the moment are rent, power, food. And, we've got the situation when my mother was alive, she only passed about a year ago, but for several years, she turned off her hot water just to keep her power bill down, and et cetera, et cetera, et cetera. So just something to think about, like when you talk to your companies. Thank you.
Just some context around that, we pay 42 cents a kilowatt compared to Auckland, which would pay about 22 cents a kilowatt. So, literally, double. We pay very high. If not one of the highest, if not the highest in the country.
No questions from me, but thank you. That context has been helpful, in particular because we had Top Energy yesterday. And just talking to them about the lines that they come from, Transpower to the rest of the lineup north that they go to. And the question that was asked of them was the lines or the main route, and you got everything that goes off, is any of that through Māori land? So I suppose with your, you know, at this point in time or the next 10 years or whatever it may be, it's only about operation and maintenance. But in regards to, not that the national network's necessarily looking for land to put in more, but just considering Māori land, a lot of Māori land is landlocked, inaccessible, or as I've heard a colleague say, a lot of virgin land untouched. So I just sort of wanted to just put that out there. Not that you're purchasing or doing anything, but just Māori land is, from a iwi that are in a space, to our opportunities to work with big entities such as Transpower for a national grid, because they'll be wanting to have a conversation about stuff, let alone also the other smaller suppliers or distributors or whatever the networks are. Again, Māori land, is that something to be looked at, and are there opportunities? So that was just something I wanted to flag. Not that that's not in your realm at this point in time.
Probably something that would be addressed in the context of how, in the RMA context at least, how proposed assets might be assessed, including on multicultural values. So while Transpower itself has no particular or specific plans to build any new infrastructure, that doesn't mean that it may not, that it wouldn't need to build something to connect to generation in the future. So it's not necessarily out of the question within the life of the current plan, but we just don't know.
Jordan.
It might be worth adding, I'm not sure, but so Transpower has a alternatives assessment process that they go through, choosing sites, options, and cultural values is included in that process, and so is the presence or absence of Māori land and SNAs and all of those things. And they also, in the consenting processes that I've been involved in, or designation processes that I've been involved in, consultation with tangata whenua is critical, and has been instrumental in changing the shape of projects as well that I've been involved in. So
Fantastic.
that's you I can think of.
Okay, well, thank you. Thank you very much for your attendance, evidence, and your answers to my questions. I'm sure we're going to be seeing you again in subsequent topics. So we look forward to further evidence from you. So farewell till.
Thank you.
Thank you for your attendance today.
Kia ora.
So that is all of the submitters that have that wish to be heard. Make it clear, there are no other submitters that wish to present evidence. We have definitely covered everybody. So we're going to be moving to that part of this first hearing where council officers can respond to the evidence that they've heard. And I just want to say we're in slightly new territory here. It's the first time we're doing this process for this hearing. So, but the way that we've initially set it up is that you get the opportunity to give us a verbal response if you want to, and then I think it's a 2-week period where we submit us a written response where you can actually write out provisions that you think you may want to amend, and having thought further about the evidence, perhaps done some further research and discussions. At some point, we'll probably interact with you and we'll have a chat amongst ourselves about whether we want to give you a direction between today and that time, or whether we'll wait to see what you come back with, or possibly even both. But what I really want to say is that this is a slightly flexible process. We need to see what works, and it may be that it works one way for hearing one, and maybe a different way for hearing two or three. So I just want to say that this is to be an iterative process if it needs to be. So I understand you do want to give a verbal response, and you'd like a little bit of time to get your thoughts together and coordinated. So we've actually arranged to have an early and longer lunch. You'll probably need some sustenance as well. So just want to confirm whether you're happy with that and how much time you'd like.
Thank you, Mr. Chair. We have been thinking about the best approach to manage the wildlife. I think our intention today is to come up with a list of things that we would like, I guess, to update you on as a starting point. And of course, as part of that, if you have any initial thoughts about matters that you would like us directly to pursue in the interim as well, we'll receive those. We will need a little bit of time. We have been writing notes, but we haven't yet consolidated that list. I think we could possibly do that as a working lunch type situation with the team. I think that's helpful to the panel to use your time efficiently today. And yes, I think that's probably at the stage what we were going to suggest.
Would you like to suggest a time that you would like to reconvene? We're at just past 11:15.
Mr. Chair, it has been suggested that we put out year one, but we can notify you if we are ready earlier.
That sounds fine.
That's helpful.
Yeah, and if you want to, if you're done by 12:30, just let AK know, and she'll wrangle us back into the chairs. So no, very good. So we'll adjourn now until 1 p.m. or possibly earlier, and we look forward to hearing first response to the evidence received.
Thank you, Mr. Chair.